who are attending their first running meet event. I hope we can make a good first impression tonight. In terms of housekeeping items, in case of an emergency, there is a staircase down the hall that will safely lead you to the ground floor. And when it comes to food, after my opening remarks, Emma and Haley will signal your table to get up and collect the food, where two running meet executives will help serve you. Moving on. So some of you may wonder, what is Running Meet? Well, we are a nonpartisan organization that exists to uphold constitutionalism, the rule of law, and fundamental freedoms by hosting events in which speakers are free to debate legal issues and topics. This is exactly what we're doing today. In this panel, the speakers will give their input on the current state of freedom of expression in Canada. And now please join me in welcoming our speakers and moderators. The moderator of this panel, Professor Baker, hands down the most joyful person I know. He's part of the political science faculty here in Guelph. Regarding our speakers, Chris Kinsinger was a former national director of Running Meet Canada and is now a practicing lawyer with SV Law. His areas of practice include constitutional law, defamation law, civil and commercial litigation, and many more. Howard Winkler is a specialist in civil litigation with over 30 years of experience and established the Winkler dispute resolution, which helps parties resolve their disputes by the means of negotiating, mediating, and advocacy. Lastly, Peter Henein is also experienced in civil litigation, and other specialties include intellectual property law, large-scale commercial disputes, product liability matters, and class action lawsuits. Additionally, Mr. Henein was a former counselor to Dr. Jordan Peterson's case against the College of Psychologists of Ontario. As you can tell, this is a very exciting lineup. And now Emma and Haley will call your table. Thank you.
On all the just so you know. Let's
It's on mute. They wanted to bring it up.
Okay, good evening, everybody. Yep, there's the pause that usually happens when I do that, so thank you. It's my great honor to be the moderator for this panel, this very esteemed set of all-stars with me. We've decided to have kind of a conversational style discussion to begin with, so that'll be about 50 minutes. And then we're going to have all your questions. Unfortunately, we tried to come up with contemporary issues about freedom of expression, and we decided there aren't any. They're really not. It's really not in the news too much. Just kidding, of course. We've got a list of questions provided by the Runnymede Society for lots of topics to think about. When we talk about freedom of expression, we should always remember that it's not just the charter, right? The freedom of expression is much broader than that and was protected well before 1982. But of course, when we turn to the freedom of expression, we're usually talking about Section 2B, freedom of thought, belief, opinion, and expression. As you know, the courts have interpreted that extremely broadly. Just about everything except for violence is included within 2B. That means all the work is really done over on the Section 1 side. So we'll talk about the two limits, Section 1 and maybe Section 33 at some point, which is also part of the limitation on Section 2B. Section 1, you'll know, is the reasonable limits clause. But in this context, I'm always going to remind you, it's not just a reasonable limit that's allowable to put on free speech. It's a reasonable limit that's demonstrably justified in a free and democratic society. So not just any old reasonable limit. It has to be a reasonable limit that applies to our particular society, which is a free and democratic one. I always like to stress that at the outset. But that's about as much table setting as I'm going to do, because our speakers are much more expert in these areas. So I've decided that I'm going to ask each of them kind of just to state at the outset how freedom of expression is implicated or impacted by their practice, and how these issues arise in their actual legal careers and legal litigation. So I'm going to ask Chris, if you want to get us started on that. We'll go in order.
We'll go in order, but you're starting with the most junior member of the panel, so I won't have too much.
Just like the court.
Just like the court, that's right. No, but it's great to be here at the Runnymede Society chapter at Guelph, especially as a former national director of the Runnymede Society, which is a role that I had the privilege of filling for 3 years. So during that time, I got to travel around the country, attending events like this hosted by Runnymede's more than 20 student chapters. Since May, however, I've transitioned back into private practice part-time here in Guelph at Smithville area, where my practice is fairly broad-based. It focuses, as was mentioned, on civil litigation and municipal law, and part of that is a focus on constitutional and administrative law. So occasionally, free expression cases do arise in my practice. I'm working on a couple right now, which we may have an opportunity to talk about during the panel, which are some challenges to municipal bylaws that restrict freedom of expression. But then I also do a little bit of defamation work as well, which, while not a necessarily constitutional area of law, is, as Howard, as I'm sure will attest, is an area of law that does engage free expression principles. That's one of the areas in which the common law has historically placed limits on free expression. So that's how at least my practice is shaped by free expression considerations.
I'll be next.
Sure.
Okay. So I'm Peter Henein. I'm a civil litigator. The work that I have done over the course of my career, generally I put it in the category of commercial litigation, intellectual property, entertainment disputes, product liability. For me, freedom of expression really hit my practice with the one case, the Jordan Peterson case. And the inroad for that, and we're going to talk about this, I think, in a little bit, is that when you're challenging freedom of expression, it's usually going to come up in the context of, or at least what I've seen, judicial review applications. When you're reviewing a decision made by a tribunal or other regulator. And so I have done regulatory work, and then this client came along, and this case actually emerged while I was managing a number of complaints that had been made to the college for Dr. Peterson. And then the big decision came out where there was the attempt essentially to discipline him. And so that became the jumping off point for me.
Howard is a media lawyer.
So I'm a media lawyer, which means that I do pre-publication and pre-broadcast review for mainly what I'll describe as the mainstream media. And essentially what they do is when the editors see an article which they think may be problematic, and essentially whenever there's an article that reflects negatively on someone or a company, that's flagged and they send it to me for review. And essentially I do two things. One, I try to ensure that the article or the broadcast becomes bulletproof so that if they're sued, they can successfully defend the action. And also I attempt to give them advice which attempts to mitigate the risk that they would be sued. And so there's two components there. What I'll say about freedom of expression and freedom of speech is that you've got freedom of expression protected in the charter. What you don't have in the charter, but what the Supreme Court of Canada has recognized, that one of the limits on free speech is one's right, inalienable right, to protect their reputation. And what the courts have said, they've essentially elevated the protection of one's reputation to a constitutional level. And so what you've had throughout time is this struggle in the courts to balance the competing interest of free speech versus the protection of one's reputation. And so that's a lot of the work that I do and I focus on. The other thing I do is when individuals are contacted by the media and they become the subject of an article, if it's media that I don't currently act for, I help those people navigate the chess match of dealing with the media and responding to their inquiries.
Thank you. I want to hear more about the chess match. That sounds like an interesting way of putting it. So now we have a series of kind of contemporary issues that I'm going to pose to the panel with some people leading the answers, but then everyone can comment on. So the first is about Bill C-63, which was introduced in Parliament when Parliament was sitting, as it's not currently. So with the rise of social media, hate speech is more common. Parliament has introduced this act, the act to, we sometimes call the Online Harms Act. There's a whole, in my question, the whole title of the legislation, which I'm not going to read because it's way too long. But we'd like to focus on the amendments to the criminal code regarding the increased penalties for hate speech related crimes. So the most extreme of these changes includes life imprisonment as a potential penalty for all crimes and federal offenses if a new hate motivation offense is attached. So Chris, I'm going to ask you, do you think this is an effective way to counter the rise of hate speech? And what types of issues can arise from legislation such as this, limiting hate speech?
Well, regarding the Online Harms and Other Stuff Act, I had one colleague once refer to it. Even though the legislation is now effectively dead in the water, given that it would have died on the order paper when Parliament was prorogued because the House of Commons did not actually enact the legislation before then. I was always very skeptical that it was going to accomplish what it set out to do, Dennis, and I was skeptical about the steps that it took specifically when it came to amendments to the criminal code to combat hateful expression. Now, to be clear, the criminal code already includes a general prohibition on hateful expression, and I do not question the constitutionality of that particular division. I think there are good reasons why those restrictions on expression are demonstrably justified in a free and democratic society pursuant to Section 1. But the issue with the proposed amendments to the criminal code that the Online Harms Act was going to make, well, there are a few different issues. The first is that it sought to introduce a new definition of hatred. And so right now, the criminal code doesn't include a definition of hatred. But what it was going to do was add this new definition that defined hatred as, quote, the emotion that involves detestation or vilification and that is stronger than disdain or dislike, subject to an exception that a statement will not be deemed to be hateful solely because it discredits, humiliates, hurts, or offends. Even with that qualification, that is a very broad definition. And the other thing that the Online Harms Act was going to do was to broaden the categories of hate crime offenses. So essentially, what would have happened is any federal offense, not just a criminal code offense, okay? So theoretically, any offense under any federal piece of legislation that was motivated by hatred was now going to be an indictable offense that could include up to life imprisonment. I think that's a very overly broad approach to combating hate, despite the fact that hate does remain a problem in our communities. But even more worryingly were the provisions that the Online Harms Act was going to introduce to allow for peace bonds against feared future hate-motivated offenses. So essentially, we have peace bonds for other crimes right now. Notably, we have them when it's feared, for example, that someone is going to commit a terrorist offense. What this would have done, though, was allowed someone to apply to a provincial court judge if it was feared that someone was going to commit a hate-motivated offense, and then that provincial court judge would be allowed to carry out essentially an inquiry to determine whether there were reasonable grounds that person was going to commit a hate-motivated offense. And we can get into all the ways in which this is problematic, but what it really boils down to is that it would have required provincial court judges to assess a person's very thoughts, to conduct an inquiry into their inner forum to determine whether they had essentially committed some act of wrong think, and to place restrictions on their liberty, for example, by imposing house arrest before they had actually ever acted on those thoughts. So when it comes to the Online Harms Act, count me as a skeptic that it was going to accomplish what it said it was going to accomplish.
Maybe just add, I think what's important to understand is that when we're talking about hate speech, maybe at the risk of sounding controversial here, you are allowed to hate things, ideas, and I guess people. But what you're not allowed to do, and what the Supreme Court of Canada has made clear, what the Criminal Code makes clear, is you cannot incite violence against people. The language in the Criminal Code, so we have 3 provisions in the Criminal Code that actually deal explicitly with hate speech, and they talk about prohibiting the advocacy or promotion of genocide against an identifiable group, prohibiting public incitement of hatred, meaning speech that incites hatred against an identifiable group in a public space where it's likely to lead to a breach of the peace. Section 319, sub 1, sub 2, says prohibits willfully promoting hatred against an identifiable group, even if there is no breach of the peace. What the Supreme Court of Canada has repeatedly come back to is that where the line is crossed, when we're talking about hate speech, I mean, any sort of physical act of violence can be judged on its face. I don't think there's going to be a lot of debate. But when we're talking about hate speech, where the line gets crossed is when you are trying to incite violence. This language about breaching the peace becomes fundamental. And so when we look at freedom of expression in the broadest sense, the truth of the matter is you are allowed to hate things. You're allowed to hate people. You're allowed to have all sorts of emotions, a wide panoply, a rainbow, if you will, of emotions. But what you cannot do is take steps or try and actually encourage people to harm those other people. And that is a line that gets addressed in some of the other areas we're going to talk about as well, which is at what point is it moving beyond an expression, a personal expression, into something that is harmful to others. And the expression, I don't know who wrote it, because I think it's been attributed to a number of people, but I love this expression, so I made a point of noting it down. But the right to swing my arms in any direction ends where your nose begins. I think that when we're talking about freedom of expression, We have to remember that fundamentally, and what I'd be advocating for, and what we have advocated for, is that you are free to express, but you aren't free to hurt people. Is it? You aren't free to encourage violence against people or groups, genocide or other atrocities in that.
So the only thing I'd add to that is one of the criminal code provisions also prohibits state public statements which incite hatred. So the question is, what the hell is that? And I'm a rule of law guy. Our society depends on the rule of law, respect for the rule of law. And as a practicing lawyer, what's so important in order to generate respect for the rule of law is certainty. And one of the problems with the current criminal code provisions, with the proposed legislation, is that it creates uncertainty, not certainty. And so I think I give it a fail for that reason. We've got a terrible problem today in our society with respect to, I'm going to call it extreme speech, and speech that can do terrible, irrevocable damage, which we don't currently have adequate legal remedies for. And part of the problem is I blame the politicians and I blame those who are drafting the legislation for not keeping a focus on creating laws that create certainty. And, you know, 2 of the 3 criminal code provisions require the consent of the Attorney General in order to bring the criminal charges. And my problem with that is when you've got something that's the subject of political will, then you lose the certainty because, you know, what the Attorney General, you know, the problem is not only what the Attorney General will do, but in many cases under these provisions, it's what the Attorney General is not doing and is refraining from doing. And so I see a lot of problems. There are no doubt there are problems. They need to be fixed, but I'm not sure that we're there.
Can I just add something to that? When looking at the proposed amendments to the Criminal Code under the Online Harms Act, the provisions that you just read out, Peter, public incitement of hatred, incitement of genocide, these things, there's a really key difference between what the Criminal Code already did and what the Online Harms Act wanted to do. All of those things are targeting the harmful effects of expression. Now, in some cases, we're essentially making an ipso facto assumption that inciting genocide is by its definition harmful. But the point is, what's being targeted is not the content necessarily of the expression itself, but rather its harmful effects. What the Online Harms Act was effectively going to do was flip this on its head and impose what's called a prior restraint. So essentially, what the provincial court judges deciding whether to issue these peace bonds would have been required to do is to look at the anticipated content of someone's expression and make an assessment that right then and there about whether or not that content was going to be permissible. And there's an argument to be made, and the Supreme Court hasn't addressed this directly in a majority judgment, but there's an argument to be made that a prior restraint on expression is never justified in a free and democratic society under Section 1. It's okay to go after the harmful effects of expression, but the state is not to act as the licensor of expression and the content of expression itself.
So you're an absolutist on prior restraint?
I'm close to an absolutist on prior restraint. I think when you get to that point where the state is deciding, is essentially setting itself up as the licensor of speech and to say, this is the boundary and this is what you're allowed to say and this is what you're not allowed to say, I think that goes beyond the state's proper authority and role. But for the state to go in and say, this expression has caused harm, or in the case of, for example, incitement of genocide, this expression is by definition going to result in harm, I think that's a different calculus there, and I'm okay with the state imposing restrictions in those cases.
So what do we think of Keegstra as a precedent? Is Keegstra now out of date? That was decided long ago before social media and all that that's happened in more recent years. And Keegstra, of course, upheld the provisions that Peter talked about. Are we now in undiscovered country that we don't know how the court would rule on this, or do we have any sense on that? I know nobody wants to predict the court.
So I'll jump in on that. I think the main concern I have with Keekstra is that, to me, the terrain has shifted as time has gone on and as society has evolved. Keekstra essentially was convicted of offenses for making statements which promoted anti-Semitism. And I think that in today's society, given, and I don't want to get too political here, but we're in a situation where that kind of speech and counter speech is rampant and nothing's being done about it. And so I think the ground has shifted. And I think that it's going to be up for the courts to decide what constitutes sufficient hate and how to interpret and reinterpret the provisions of the criminal code to apply to today's society.
I think when we talk about freedom of expression, I was talking to you earlier about this, one of the concerns, I think, is that the dialogue or the nature of dialogue has shifted from an exchange of ideas to teams or a tribalism, where if you express one opinion, that means that you are assumed to adopt a whole laundry list of other opinions that you may not actually, or beliefs that you may not actually have. And so everything has become a fairly black and white debate. You're either with us or you're against us. There is no nuance. There's no opportunity to express an opinion about a specific issue without having your voice lumped in with other voices. That's problematic in and of itself, just because it leads to an overly simplistic and I would say reactionary response from the person who does not agree with you. But I think that the other issue is that the rules, I guess, when we talk about what we can all agree on, the rule should, what we can all agree that the rule should be, that only works as long as our attitudes never shift. And so when you look at freedom of expression cases from the early days of the charter, I mean, one of the prominent ones that came to mind, as I was kind of delving into this, was the Little Sisters case. Little Sisters dealt with it was a bookshop, a niche bookshop that was importing what was deemed lesbian erotica, and it was being prevented from coming in at the border. And so that's what a freedom of expression case looked like, 10 years ago, 20 years ago, 30 years ago. Now we are seeing cases dealing with challenges to vaccination laws. So people expressing opinions, medical professionals expressing differences of opinions on whether vaccines work or don't work. Gender rights. I mean, transgender rights have become a huge subject of debate. And so the expression of opinions about those have become a real flashpoint. So when you think about what we were arguing about, the expression that we're saying needed to be protected, it was generally, if I can put it on a political spectrum, left wing. Now we've moved to a point where, and I don't think I'm telling you all something that you haven't figured out yourself, but the people who are decrying the need to have their expression protected are at the other end of the spectrum now. And so the rules only work if we can all agree that we're never going to change our opinion on what's right and what's wrong. And so, I mean, there's cases, and I don't want to go take too much more time on this, but I mean, there is a case that we were looking at. It was a lawyer who was, I believe, regulated by the Law Societies. It would have been the Upper Canada Law Society, as it then was, so the Law Society of Ontario, for being an avowed Marxist. And the problem was they said, no, you can't, we're going to kick you out. And I'm oversimplifying, but basically the idea was we don't accept those views and therefore you are not going to be allowed to practice law. And I think by today's standards, you would never accept a law organization refusing to license somebody because of their political belief. Again, we're not talking about violent action. We're not talking about inciting hatred. We're talking about literally a political belief. And I think what we've seen in the United States, and I hate to invoke it, but it was bound to happen during today's discussion. And you see how an entire country backsliding culturally. So we're now, how recently was it that they re-argued abortion laws that you thought, didn't we all agree that we were all cool with that and we're now moving forward? Nope, we're moving all the way back. And that's why I think when we're talking about, even with the rule of law and predictability, we have to keep in mind this idea that culture apparently doesn't just move forward. Apparently it ebbs and flows back and forth. And there is a subjectivity to any given point of view at any given point in time.
I think we have a lot of stuff. Sorry, Chris.
I'll just say this quickly about Keekstra. My primary issue with Keekstra is methodological, and it's the way Keekstra sets up this so-called contextual approach to evaluating restrictions on free expression. I'll say something maybe a little surprising as someone who occasionally litigates free expression cases. I think it is the bar has been set much too low to make out a limitation on Section 2B of the Charter. And the upshot has been that these cases are being decided under Section 1, and they're being decided under this so-called contextual approach, which focuses not necessarily on the harms of expression and the objective verifiable harms that flow from expression, but on whether that expression is deemed to be high value or low value, and its alignment with the supposed values that underpin Section 2B. And this has created uncertainty for those litigating free expression cases, but it's also in many ways, it's essentially just set up the state to have more grounds to justify restrictions on free expression. Somewhat paradoxically, I think it would be better if we had a higher bar to get in, if we designated fewer forms of expression as being subject to the 2B guarantee. So right now, as you said at the outset, Dennis, it's essentially any kind of nonviolent expression gets in through the door. I would probably want to see that set a little bit higher, that bar, with the converse effect that the bar for justification under Section 1 is also set higher, with a focus on, again, actual verifiable harms, rather than with a subjective assessment about whether that speech is high value or low value.
And that core periphery distinction that used to be a big deal is completely over. Right now, political speech can be, if it's a tweet about the election results, which is core political speech, that could easily be limited under Section 1. I guess one more kind of point on the Online Harms Act. Chris, you gave us the definition of hate that's in the act. Is it possible to really legislate that well? Peter talked about the certainty issues, right? So I could argue that instead of leaving hate, the interpretation of hate up to a judge, put it in legislation. That's Parliament talking. That's a good thing in lots of situations. Is it possible to do that? Is this an impossible task?
I think what essentially Parliament, or the drafters, I should say, of the Online Harms Act was trying to do was it was like when they were drafting the legislation, they had Canley open and they had Watcott open, and they basically copy pasted from Watcott into the legislation. But the point that I think you're getting at, Dennis, it's very difficult to nail down, I think, a legislatively workable definition of hatred, which again is why I think it's better to avoid trying to define it all together and focus on what are the harms that is trying to be prescribed here. Because what we need to remember is that the purpose of criminal law is to prescribe public evils. It's to prescribe things that are in and of themselves deemed to be a public evil and will result in some kind of harm, whether that's societal harm, whether that's actually physical harm in some cases. I think that ought to be the focus, and that, to Howard's point, will result in greater predictability. It allows people to actually order their lives in accordance with the law, rather than wondering, am I onside or offside of the law, which was a big concern with the Online Harms Act, particularly when you're getting into the prospect of peace bonds. How were people going to start self-censoring their own expression for fear that they might have a complaint brought against them and wind up before a provincial court judge trying to assess whether they were likely to commit a quote-unquote hate-motivated offense?
Can I just
Go ahead.
throw out one, just play devil's advocate?
Please.
Why not? Being recorded might as well do it. I think that the only point I wanted to make is that, you know, when we talk about people ordering their lives, I mean, these freedom of expression cases, these cases where constitutional challenges are being made are not usually in, you know, the milquetoast areas of our lives. Nobody is being challenged for saying, I think kittens are cute and fuzzy kittens are the cutest. Nobody's having a fight about that. Where the speech is coming under attack or is being challenged, they are generally fairly significant, strident, broad, aggressive statements. I say aggressive, I mean in terms of a point of view. They're not generally sitting somewhere in the middle. And so I would at least challenge the question, at least for the purposes of this discussion, that maybe it's not that hard to order yourself or to understand what the parameters that you're able to operate in. Because again, the cases that we're seeing over and over and over again are expressing what I said earlier, fairly, I want to say, black and white opinions about certain things.
Well, and I just, this may be a transition, whether ready, into Peterson. You know, my sense of the cases is, and again, I come back to predictability, is generally speaking, it's unpopular speech and unpopular individuals that are being targeted with respect to these complaints. And so, you know, Jordan Peterson was an unpopular individual to the mainstream and no doubt to the bench. And without sort of commenting on the views that he expressed, Ezra Levant is again someone who expresses extreme speech. He's an unpopular, disliked person, not only in the mainstream society, but to the bench. And so you've got decisions being made by judges, I fear, in part motivated by their dislike of the party before them and not guided sufficiently by what should be a strict legal test and an assessment of the speech. And so I don't know whether that's a segue into Peterson. I find it really interesting, but like I'm just, maybe I'll have other comments on it, but it's a decision that I'm shocked by.
Is everybody familiar with the case? Put your hand up if you're not. Okay. So for the two of you, I'm going to tell you a little bit about the case. Everybody else knows this already, so y'all can look at your phones for a few minutes. Let me step back first of all. When we talk about a judicial, this was a judicial review application, and it was. Does everybody know what a judicial review is? It's okay if you don't. All right, I'm seeing a lot of nodding heads. All right, trying to figure out where exactly people's level of knowledge is. We're about the same, I think. So this is good. So because it was a judicial review application, when we want to talk about kind of the meat of it, or what I, certainly at the beginning, I thought this would be the meat of it, we're going to talk about his tweets. That's not how these cases are argued. At least that's not where you start, and that's not where you spend most of your time. When you're dealing with, in this case, the judicial review application largely dealt with two cases. Doré and Vavilov. I'm not going to tell you what they're about because I'll be honest, I don't remember. But what Doré had to do with, what Doré is, what the relevance of Doré is Doré talks about the charter analysis that has to be conducted by a regulatory body when they're making a decision. Vavilov talks a little bit more about the reasonableness, whether or not the decision is sufficiently reasonable. And so when we're arguing about the college's decision, which I'm going to talk about in a moment, we start off by talking about how the college balanced, or did they balance, the charter rights sufficiently against the conduct that was being complained of. And then we talked about the reasonableness of the decision. And then, after quite a long time of on our feet arguing in front of the divisional court, we then got into the actual content of the expression that was at issue. And so kind of with that, I think it's helpful, I think to kind of talk about it at a high level, not really think about the comments that were at issue, I think it's helpful to take a moment and actually talk about what were the complaints. And as a starting point, I don't want to take too much time. I'll move through this relatively quickly. There were, I want to say, roughly 12 to 19 complaints. I cannot remember the exact number. These were complaints that were made largely online. People were tweeting at the college saying, how is it that this person can hold themselves out as a clinical psychologist? These statements are offensive. Let's talk about some of the statements. First of all, he went on the Joe Rogan Experience. Joe Rogan is a podcast. Podcast is like an online radio show. Is everybody with me so far? Okay, great. So he went on the Joe Rogan podcast and he made a joke about homeless children or impoverished children. Joe Rogan asked him if he was being facetious. He said, yes, absolutely. He referred to a former client as being vindictive for having filed a complaint about him. He referred to an Ottawa City Councillor by the name of Catherine McKenney, who uses they, them pronouns as a, quote, appalling, self-righteous, moralizing thing. He tweeted in respect of Elliot Page, a transgender actor, remember when pride was a sin and Ellen Page had her breast removed by a criminal physician. He referred to then chief aide to the Prime Minister, Gerald Butts, as a prick. He tweeted in response to the Sports Illustrated swimsuit edition cover featuring Yumi Yu, who's a plus-size model, quote, sorry, not beautiful, and no amount of authoritarian tolerance is going to change that. So that's essentially the statements that were complained of. What happened was the college rendered a decision saying, you need to go get social media training, really sensitivity training, because this is offside our guidelines. And so the judicial review was challenging that decision, saying that that decision was wrong. And our arguments were largely first framed under Doré, saying that the college did not properly balance his charter rights. And in fact, we argued that it was fairly perfunctory acknowledgement. Yes, we acknowledge that Dr. Peterson has charter rights and his freedom of expression is protected. And then we argued that the decision itself wasn't sufficiently reasonable. And that's when we got into the meat of the analysis and said, a lot of these are jokes. A lot of these are political commentary. A lot of these are personal opinions that he did not find a particular model attractive. And so when we were looking at that, the argument was this particular college, this particular group should not be governing what we would argue at that point was off-duty commentary by somebody who, yes, was holding himself as a professional, but was not even acting clinically. And I don't mean in those specific contexts. At that time, he was not running a clinical practice. So he is somebody who identified himself publicly on Twitter as a clinical psychologist and in interviews. And the comments themselves were challenged. And kind of, I think, sets the table. I don't know if others want to comment at all. Not at this point. Yeah.
Well, I mean, I can weigh in and say, you know, I don't agree with any of the comments that Jordan Peterson made, but I defend his right to have made them. And my big concern with what's happening, especially what happened in the Peterson case, is we set up these regulatory bodies, administrative tribunals that are intended to be more specialized and more efficient at resolving issues of professional misconduct than a court would be. And so they're specialized tribunals, and the courts give deference to their decision-making because of their expertise, and deference because they don't want every case ending up before the courts and clogging the courts. The intention is to provide an alternative to the court system. But the problem here is that while I recognize that the College of Psychologists has subject matter expertise with respect to the practice of psychology, they don't have subject matter expertise with respect to speech. And what they essentially were doing was assessing the quality, the nature and quality, and I guess effect of the speech of Peterson. And so you have the college essentially finding that as a result of his speech, he needed sensitivity training. And that ends up at the divisional court. The divisional court says, which is really a more appropriate place to assess the quality and nature of speech, says we're going to rely on a Supreme Court of Canada decision that says we need to respect the qualifications and the subject matter expertise of the college. And the test for overturning their decision is essentially, and I'm going to overgeneralize, was the decision reasonable? And they said that the decision was reasonable. And so my problem with that is now we've got issues of speech being decided by specialized tribunals that are not necessarily, the tribunal members are not necessarily, or in many cases, are not lawyers, don't have legal training. They've got counsel to advise them, but they're fulfilling the kind of judicial role that we reserve to judges of our courts. And so my problem with Peterson is that the environment was the wrong one in which to assess speech, and the court should have been more willing to step in and itself consider the nature and the value of speech, but they refused to do it.
Can I add just a couple things? Sorry, I know I've done a lot of talking about this case. A handful of notable people who did not complain to the college. Catherine McKenney, Gerald Butts did not complain to the college. Yumi New, the plus size model, did not complain to the college. Elliot Page did not complain to the college. They were random, or rather they were tweets from people who had no direct relationship to the people who were being commented on online. And it begs the question, and again, I think it's fair to say whether or not, in fact, I will say whether or not you agree with any of the opinions, the point is we're talking about protection of a fundamental right. And so if somebody tweeted online, I think people with red hair are the most beautiful people in the world, or I think people with red hair are or let's say bald, bald guy. Pointed where it needs to be pointed. I think bald men are the weirdest looking people in the world.
How hateful.
I know, it's awful. I'd like you all to file if you might. Again, when you start thinking about the content and the fact that that's a negative comment about a particular group of people, but if somebody makes a positive comment, I guess that's okay. So now what we're saying is that in a society where we protect your free speech, your freedom to say whatever you want is protected absolutely, as long as it's nice. And I think that's a fundamental problem.
I'll add one comment. I agree with everything that's been said. I think it's an important distinction to be made here because when we're talking about the Peterson case, of course, we're not just dealing with constitutional law principles, we're dealing with administrative law principles. We're dealing with the authority that has been given to these regulatory bodies, and in this case, a professional regulator. I'm not surprised by the outcome when we go back to cases like the Supreme Court's 2018 ruling in Trinity Western University. These are a lot of the same issues that came up there. We're not dealing anymore with the criminal law context I was speaking about before, where the federal parliament has a broad authority over criminal law and over harms that might arise from certain types of expressions. We're dealing here with bodies that have been set up to professionally regulate certain professions and determine whether people have the qualifications to practice within certain professions. And increasingly what you're seeing, this is what you saw in the Jordan Peterson case, and this is what you saw earlier in Trinity Western, is that the considerations that these bodies are focusing on really have nothing to do with the actual profession in question. They aren't questions of professionalism. They are these extraneous questions that really don't speak to someone's ability or competency to practice in a certain profession. And my own view is that that was essentially what happened in the Trinity Western case. There was never a dispute. How many of you, by the way, are familiar with the Trinity Western case? Okay, so really quickly, essentially Trinity Western University is a Christian university based in British Columbia. They were going to set up what would have been the first private law school, the first religious law school in the country. As you might imagine, Trinity Western University has a religiously informed code of conduct, which includes conservative stances, theologically conservative stances on many issues, including issues of sexuality. The law societies several law societies took issue with this and decided that notwithstanding the fact that there was no question that Trinity Western's graduates would otherwise be competent, ethical, capable lawyers or law graduates anyway, who would go on to apply to become lawyers, that because of these stances that Trinity Western, the university, had taken, that they would not recognize graduates of their law school. So what you in effect had were the law societies deciding to bar from licensure law school graduates who were otherwise qualified based on their perceived views, not even necessarily their own views, but the views of the law school that they had attended. So I would simply say that when we look at the through line here, it's not surprising. In that case, went all the way up to the Supreme Court, and as with the Peterson case, the court held that the decision by these law societies had been reasonable under the exact same framework.
For my law and politics students out there, the case Dore really gets at the root of some of these issues where we empower administrative tribunals to take on some of these concerns. Some of the things Howard talked about their, and Chris, about their expertise are open to be questioned, I think. We got lots of time, some time for questions, and I'm sure we'll come back to the Peterson case and maybe the Emergencies Act. But there is one big piece I want to put on the table, which is Ontario's anti-SLAPP legislation, which I'm not sure a lot of people know about, but it's really interesting stuff. So SLAPPs are strategic lawsuits against public participation. I always don't look at my notes to remember what it stands for. But Howard, you were talking earlier about the chess match and speech and counter speech, and this is one where we really see it kind of playing out, right? With people using law to silence people and trying to overcome some of those problems. I know you've written critically of the Ontario law and actually in favor of a more UK and Australian approach, I think.
Right.
So if you could just walk us through that a bit, that'd be really interesting.
All right, so very quickly, my view is that the law in recent past has consistently shown a preference for protecting freedom of expression. We had the Supreme Court it used to be in defamation cases, for example, that if you got a statement of fact wrong and it had a defamatory impact on someone's reputation, you were done. You were cooked. You were going to be held responsible and you'd have to pay damages. The court adopted this new defense called responsible communication. And it's not just responsible journalism, it's responsible communication. So it was intended to be broadly applied. And what it basically said is, we're now for the first time going to protect your right to be wrong so long as you behave responsibly. And for the media, that essentially means there's a long list that's not exhaustive. But what the media does now is when they reach out to someone for comment, it used to be the person could say, you know what? I didn't come looking for this story. I'm not going to help you by giving you any information, and you better get it right. And that's how we used to be able to respond. Now, after this decision, you couldn't do that, because if you reached out to a subject and you said, here's what we propose to report, and we'd like your comment on it, and you refused to comment, that almost gave a license to the media to then publish whatever views it is that they were proposing to publish. And so that strengthened the protection for freedom of expression. And then in Ontario and BC, we came along with this anti-SLAPP legislation, which basically says, if you get sued for defamation, you now can bring this summary, what is supposed to be a summary motion, to have the action against you struck out. And the legislation set out this very complicated series of substantive tests, which in some cases forced the parties to incur $200,000 to $400,000 in legal fees to pursue what was supposed to be this summary motion. But the bottom line is that there's a provision at the very end of the legislation that provides the court with the right to weigh the competing interests of the right to protection of the expression as against the harm that the expression has caused or is likely to cause. And that is a great component of the legislation. And the legislation is well-intentioned. The problem is that these motions, by virtue of, I think, poor drafting, itself became the subject of lawfare. So what happens is you get someone being sued by a wealthier opponent, someone who wants to silence a critic. They bring a lawsuit against somebody. That defendant, then seeks to use this legislation to get a summary dismissal of the lawsuit. And what happens is that the plaintiff then uses that motion to, in a sense, have a mini trial of the entire issue and incur, as I said, hundreds of thousands of dollars. And so if you're the unfortunate individual that made a tweet, that was critical of some corporate interest or some well-funded interest, now not only were you sued by them, but when you tried to bring a quick resolution to the case, you got involved in this terribly complex motion, which was intended to be a gatekeeper for litigation. It was intended to dismiss actions in respect to expressions in relation to a matter of public interest. And again, well-intentioned, like the online harms legislation, but in my view, just a terrible fail.
Chris, you're on the verge of a comment.
No, nothing really to add to that. Howard, I guess I would just ask you, is it fair to say that the anti-SLAPP legislation, it was essentially created to protect David from Goliath? And then Goliath realized that actually he could start using anti-SLAPP provisions to his benefit.
Absolutely. I mean, that's true. So the legislation and the difficulty is, and this is where, I don't think when I think the legislation is well-intentioned, but they ended up using language which had never been judicially considered. And so it left it to the courts to wrestle with this legislation to try and figure out what it meant. And that resulted in a ton of litigation itself. Instead of, in my view, and I would say with respect to the Online Harm Act, it's better to build on existing law in terms of, what I said earlier, this need for certainty and predictability. Build on existing law where we've got jurisprudence so people really know what to do and how to behave. And unfortunately, the anti-SLAPP legislation just created this abyss where it became counterproductive.
I think the only thing I would add to that, and you're probably familiar with this, Howard, but one of the challenges when you practice defamation law and you have clients come and they feel that they've been defamed and they're thinking about bringing a case, it's a very tricky area of law to litigate. And more often than not, what I find myself doing when I have those clients come to me is discouraging them from pursuing the case, because very often the very thing that you end up doing is you draw attention to the very statements that you would rather not have publicized. The Streisand effect. But anti-SLAPP legislation has just compounded this. And it's like, even if you can get to the point where you can make out defamation and we have a response to all of the available defenses and you consider the Streisand effect, the potential costs just to get to a point where you are actually having a full hearing on the merits can be years down the road, and as you say, hundreds of thousands of dollars. So from an access to justice perspective, it's just made things even more difficult for potential plaintiffs in defamation cases who in many ways already have the deck stacked against them.
I say to clients when they come to me wanting to sue for defamation, is I say to them, first of all, it's a terrible investment of money, that you're better off buying a lottery ticket. So if you're doing this because you think you're going to hit the jackpot, then that's the wrong reason to do it. The only time it really is, I think, makes sense to sue for defamation is if your commercial interest or your employment interest has been so badly affected that you need to vindicate your reputation in order to re-enter your community, re-enter your employment, revive your business interest, then you've got an economic interest to do it. Or if you're sufficiently wealthy that you can afford to fight the principal. And if you don't fit within either of those two categories, it's a really tough piece of litigation to pursue.
So I'm mindful of some of my course evaluations that sometimes say, you went 2 hours and we got through 2 slides. So I worry that we haven't got through all the questions here, but I do want to have, this is your session. So I want to hear your questions, and the panel, I'm sure, is eager to hear them too. So any of the topics or on new topics. We didn't talk about the Emergencies Act or anything like that. So if that's on your mind, feel free. I don't know if we've got a mic. Yeah. Say your name and then your question.
Hi, my name is Aaron Geiger. I'm writing questions down on my phone, sorry. So you had mentioned cases of the phenomenon